what she's doing. Like, it was just evolving constantly. But yeah, so they were trying to get through it, so we're in there shovels. The mortars.
Did you ever meet Jack Nicholson?
They like, hey, where are you?
When we, you know, you could have just said the entire firefighters.
We heard of it.
He was in contact with Carlos. Carlos doesn't want to do. I tell him what it be.
I guess the point he Devin
Yes.
just, you know,
That's
that's
just how it does it in big way.
but it's like, oh, you do 10 reps, I'll do 10 reps through the show.
So, Carlos, we all talk what we got there. Suggestion to, first of all, you need to see crews.
We brought that up.
It's just gonna override the system. I looked, you're right, I'm an older millennial, you're just a regular millennial, apparently.
Forgive you.
You know what's funny is the millennial cutoff is 1 year before my half brother's birthday, like birthday year, so he and I are different generations, so I just assume you're the same age as him. Why? I don't know. He's apparently 6 years younger than you. Just made that up in my brain.
We had a guy who was like, chose the idea of being all those millennials.
Spinal still monitoring the security in the room, and there he thinks there's somebody in there, so thinks he can hear somebody in there.
Really?
Yeah. Sounds like Wolf calling around.
I went back in the room.
Okay, well, he's on it.
Yeah.
He detected an unusual noise, so what are you doing in there, Lyle?
Put my sunglasses back on the table and poured a cup of coffee.
Okay, well, it seems like pretty normal stuff, if that's really what you're doing.
I also rifled through all your stuff to make sure we don't have any moles.
Good. Well, apparently I sabotage your equipment again. Oh, shit. You know what? I do need to go back in. I need to grab my notes. Where's the keyboard?
Jeremy's got it. I tricked him.
Seems like we have all kinds of time. No one showing up for your
But
sides.
I'm not looking for it, so, you know.
Jim, you're a shining beacon of technology.
Thank you. It's funny, she saw
Just like it.
there. But team leader was the other one. Can't really pull the wood over.
Where's Les?
Somebody comes.
He was on the Zoom in there.
How was it?
Yeah, I'm not sure if he's out of town or just couldn't make it. But we could hear Dad's kids might be
Babysitting?
watching the kids, you know.
Summer vacation.
Like, hey, you big stud, grab that mop, go, you know.
Yeah.
And that was the first. By the time down to here, you know, they 5'7", most of them have to work with somebody. All those words in my book.
The big thing is that everyone has a boss, there's not. It's just he's in person to another people. Then the fire department has it, chain of command out of it, all those things.
I'm trying to manipulate everybody.
What's going on?
And then
It seems to be a lot more of that.
A lot of noise.
Yeah.
It's COVID probably.
Every time they test on it, they gotta send something.
Yeah, they have the IOJ, and so they fill out the FOI, the first report of injury, and we have increase of cases.
The last time, now there's over 50.
Yeah, there's a lot of.
Did anybody tell us to come in? Maybe we're just here and we shouldn't be.
They said 30 minutes when I saw them at 9:56.
I actually said maybe after you left.
Well, I guess we should go down and check so we don't waste our time. We can go through articles and they're not gonna meet today. I mean, how could they possibly meet unless an iPad is operating correctly? It's impossible.
Are they having technical issues on their?
Yeah.
Yeah.
I was hoping I had recorded, but they haven't been able to even log in, so.
Oh.
I think the Ethernet, having issues with Ethernet. So for once, it's better to use Wi-Fi than it is Ethernet, which I've never heard of in my life. But everything in this world is upside down now, so why wear clothes? Why drive a car? Why?
It's good.
Right? Why go to work?
I honestly, I've been like, what am I doing? Like, what,
And I-
this is important. What is important? No, who cares?
They come.
Yeah.
No, you can't.
I'm just hoping when I hit record it works now. This morning.
They said they're coming soon, so. I think we could probably send the link now and it'd be safe.
I sent it.
Yeah, what's that?
I sent. I
Oh,
just
did
sent
you?
it.
Okay, good deal.
I said I'll begin shortly.
Perfect.
Actually, I already won. You know? But in the moment. I decided to start this session with soothing binaural beats in the background to regulate your breathing. Yes.
Seems a little trippy if you look at it. Blue, how the light everything is.
Oh, yeah.
Some reason the bath,
No.
What's that, Tim?
passive is not working. Passive works with a direct HDMI input.
Oh, it's not working?
Passive.
Works. Working really well, wasn't it?
Yeah.
So, Bob, I don't know if we told you we dropped another one.
Maybe Sarah said.
Oh, this
Yeah.
morning,
Yeah.
someone else? Chief Myers. Oh, goodness. Nice and flag. Yeah. Been having a rough time. Yeah, you wonder why we always want to move us in there.
Colorado to my,
Excellent.
my iPad.
Excellent, excellent. I can do it already.
I know.
It's not nice.
It's nice to know.
Maybe I'll sit down here in case.
Wanna try it again?
Finishes this meeting. Probably a better
Yeah,
idea.
try. Same thing? It's working now? Okay, good.
Whatever you did, it worked, Bob.
Oh, and Lowell. I mean, Woodruff too, I should say. Oh, yeah.
Oh, Lowell's on here? Well, you didn't tell me that. We can't do this on Lowell. He's the glue. He keeps this whole thing together.
Yeah, I know, he is Friday.
First draft.
Probably driving bulldozers.
No, he also has COVID, is what I'm telling you. Yeah, yeah. So we're,
Just getting slowly picked up.
We certainly look forward to his presence in the future. How do you want to start?
you can go ahead.
Okay. So day 13. We have not TA'd anything in quite some time, so I hope we can do that soon. So I think we have we have 4 scheduled days left before the 60 days are up. And I think we have 7 physical days between now, maybe 8 if you include tomorrow, which I doubt we'll do, between now and the end of the 60-day statutory time limit. So because of the way the proposal went last time, some of this needs explanation. The management rights has the one asterisk, that's part of a bundle we've been talking about. And then the 2 asterisks are things you gave to us that weren't in writing, that were in writing as of yesterday, but had not been presented the wage has not been presented, you haven't responded to our articles specifically, I think you said that verbally and in writing. And then the other ones you have not really laid out. You went through them, I think you went through 5 articles in 1 minute and 14 seconds, so really not laid out an interest-based sort of on that. And I do want to talk about wages really quick. So as you can probably know, we have hundreds of people, I remember watching these videos, and they were very disappointed when they saw the city wage package. Some of the members called it a joke, called it a non-starter, and mostly they're just demoralized because they look to their leadership to be supported. And I think we made a really good justified case of what they told us. We told y'all, they're struggling. And what we hear from y'all is not much care for that. And I understand in bargaining you have high offers, low offers, but there's also offers that are too high, there's offers that are too low. And I think we have a long way to go to get a deal at the table. I hope we can do that. But we have, more important than we think and you think is what the firefighters think. And they're not telling stories when they say they're struggling. They're not telling stories when they're saying that their families are struggling. They mean it. And when we hear these things that kind of disregard that, like there was one example I remember, I thought it was, I knew it'd be taken the way it was said. And I think it was meant to be taken that way, actually. Is that, well, you guys might be struggling now. I'm paraphrasing a little bit. Yeah, it's a tough environment, and maybe the wages aren't there, but you've got this asset in your home. And so this whole premise of being cash poor but asset rich is kind of, it's very discouraging. It's almost insulting that we should struggle for 20 or 30 years and have this asset in the future when we're looking for our leadership for some relief now. So I'm not going to go any further than that, but I think that needs to be said. So the ABL was one of those 5 articles. Leave, personal deployment. You actually sent that article over, but we didn't talk about it much. So hours of work, overtime, and cadets we haven't seen in quite some time. I didn't look at the date on that. It's been quite some time since. I think we want to go back to original language. You thought some of your language going back and forth on was more meaningful, or we just need to pull that one back up. Drug testing, in all fairness, we just gave that to you last time, but it should be very close to what we've been working on with EMS, is our understanding. Other parts of the bundle of entire agreement, maintenance standards, and termination agreement. I think that is probably the low-hanging fruit now of that bundle. I hope we can make some progress on that. Excuse me. On our side of the table, we have our bundle we've been working on. Discipline and health-related. Well, you know what? I think I have health-related benefit on both sides. I'm sorry. I shouldn't have it here, actually. You sent it to us, but we need to have you discuss it, if you wouldn't mind, and characterize how you believe you're meeting our interests with your proposal coming back to us across the table. And then I think either today or tomorrow, we will have that wellness article we'll put out there. We promised. I know you guys are waiting with bated breath on that. So it's coming soon. So. And there was a time when Lowell did this sort of move where he pulled us out of caucus and talked about, hey, I don't think you guys are trying to add clarity to the situation like we are, and we assured you guys that we were. And I think that was a good, productive discussion. And I think we need to have one of those critical discussions again. And if we're doing something that's stopping y'all from making a deal, we want to know what that is too. So it's not a one-way deal, but we think there's a lack of discussion on specific interests the city is trying to achieve when you bring your articles. For instance, we had 5 articles presented in 1 minute and 14 seconds. That's probably the most extreme example, but there's several examples of that on your more substantive articles. Total control does not articulate a city interest. So when you say, we want to do hiring 100%, you're out of it. And we say, we don't know what your interests are, so we can figure out how to find common ground, and you just come back with, no, we just want total control. That does not articulate an interest that we can work with and try to find middle ground to meet everybody's interest. Barely any discussion on how the city's addressing our interests. I mean, this relationship we have is supposed to be important in interest-based bargaining. We don't believe that some of this is interest-based bargaining. It seems very positional, which I know that I'm not naive, I've been doing this 7 times. And I realize that sometimes you get to positional bargaining towards the end, but it seems like the effort has not been there. Now, to be fair, I think on some articles, we've had some very candid conversations, came to some real meetings of the mind. But in fairness, I think those are more non-substantive articles. If the articles really matter, we don't seem to be reaching that meeting of the minds that I was hoping we could. And it's making it very hard to figure out a way forward to make a deal. We have very little time to do that. So we are absolutely committed to doing it at the table still. We have a lot of work to do, and I just think we need to be very honest with each other to get there. And you know, this is what we agreed to, and the parties agreed, this is on ground rules, to focus on issues and not personalities. Maybe not bringing up my family would be a good thing not to do, you know. Focus on interests rather than positions, and make decisions by consensus when possible. Every effort should be made to promptly agree on accepting existing contract articles, acceptable existing contract articles. And so here's some of the examples of lack of discussion. So we put out a conceptual proposal on wages, I think the second session was June 3rd. And then we put out a proposal last session, an actual proposal, which is very similar to what we put out on the 3rd. I don't think there was any surprises in there. If they were, they're very minor. So the same day, y'all put out a proposal with nothing in writing and don't really address our proposal. Yeah, and now I want to acknowledge, I think verbally and in writing, you said you would address our proposal. So that's why I have the word yet in there. Article 10, ABL, we proposed on 5/16, the first session. We got a 23-second response on it last session, last time we met. Article 12, we proposed on June 3rd. We got a 23 response, a second response to it last session. And nothing in writing until last night, or like this afternoon. Article 14, we proposed on June 3rd, nothing between then and yesterday, and we get a 23-second response on the average. And the same with overtime. I don't want to be too redundant here, but I think you get the point. In health-related benefits, we proposed it on 5/16. I believe y'all said that you would be looking into Fort Worth and do some research, and all we got last time in a 23-second retort is that you're not interested in it. So again, and I hope you guys do the same to us. Tell us what we're doing wrong, but we're not being responsive to you, so we get a deal at the table. I'm sure there's a question on both sides. So here's this 23-second each for each article. Little video. I know you guys love my video clips, so go ahead and play one here.
At this point, we are not interested in your double time proposal. We don't believe that staffing dynamics have made that necessary. We're not having a problem filling those shifts.
So that's 12 seconds. Disregarded an entire article we put out on May 16th.
Well, Bob, before you continue, I think you're being a bit disingenuous in the way you're projecting this.
Oh, really?
We gave you our conceptual wage proposal the other day. We told you we would be willing to discuss any of these. Any of these you wish to discuss further. You said, can we get these in writing? We said, we can reduce our conceptual proposal to writing and get it to you. These weren't the complete responses. It was our conceptual proposal to you.
These are responses after a month and a half of waiting.
I understand
and we got
that.
12 seconds.
I do understand that. But I think
those
you're
are the facts.
disingenuous in how you're doing it, because we told you we would be happy to discuss any of them and ask for specific ones that you wanted to discuss.
I disagree.
So
It's
that's fine.
disingenuous. We waited a month and a half and got a 12-second response. Those are the facts.
We gave our conceptual proposal and told you that we wanted to discuss all of them with you. That's not a 12-second response. Here's our initial response. Let's continue.
After a
talking.
month and a half, yeah. So if we get something today, that's great. That's what we hope to do. So let's make it right.
Okay, continue with your.
So let's just, we'll talk about, there's a lot of misconceptions even in this minute 14, where it appears that maybe you're not talking with management or maybe you're not listening to what we said at the table. But, we'll address those when you address those articles. We'll just play this for now. So that's ABL.
Agreed. Changes in APL, we think it's sufficiently funded. I think that you probably know, I can't remember if we officially indicated that we were opposed to the
this was the article where a month and a half ago, you guys said you guys do some research and fact finding. And what people get back is that you're not interested in doing it.
Trust line, we agree to, provide that data, that's available, and be able to, and I think we have a proposal on that, we'll probably send to you. We are not accepting the additional leave provisions that you put on.
We're having the same sort of issues, I guess, but this is leave provisions. They go on to say there's some legal issues.
Continuing to look at,
And just what Lowell's doing,
question, we have some,
I'm sorry, Doug.
what Lowell's doing here is basically summarizing what we weren't able to present on that day. So we left early that day, I think we left about 2, and then we just decided to email you the proposals that were part of the trust, that were part of some of the leave provisions and things like that, that we didn't get a chance to discuss, but we wanted you to have over the long weekend, that we are very willing to walk over today. So it wasn't that it's here's 53 seconds of 5 articles. It's here's what we'll send you, here's what we're anticipating to discuss.
And I appreciate that explanation, but from our side, we're presenting our frustrations because most of these articles we've had on the table for a month and a half, and then we hear a 30-second response or a 20-second or a 12-second response. And even within those, this is riddled with inaccuracies. It's riddled with inaccuracies. For instance, overtime. We're not willing for your double time proposal. Well, there's other things besides that in there, but because you're not having any trouble staffing issues. We got people in this room that worked 2 mandatory shifts in the last week. You know how insulting that is to our membership to hear that on the thing, that you're not having trouble staffing people? That's getting to be a problem. And I'm trying to express this foundation so we can move on and try to get a deal. But this is, I don't need to play the rest, you know, you were there. But, and we can, as you address the articles, we can address the other inaccuracies in this minute 14 second, which 5 articles were essentially dismissed. It's riddled with factual errors. It's almost like there wasn't much thought put into it. So anyway, so examples of total city control. When you say hiring, we just want to take it over, and we say, we want to know what your interests are. Hey, if it's a vendor, we want to have that discussion. If there's some great ideas, like I believe Devin says that were pro-offered, we want to hear them.
And what we sent over last week was Article 17, and you'll see that I think our interest really does lie with the vendors, which we did talk about when we first presented that article, and we'll go over it today.
That's great.
Yeah.
That's great.
So I feel like some of those issues.
So maybe this frustration is already going to be solved after this.
Just having some discussion today might actually resolve a lot of that.
So we have 7 days maximum left before the statutory period is over. And we want to continue to operate in good faith. And I think it's appropriate to discuss the impasse procedures because we've never been through this before. And for planning purposes, I think we need to spend a little time, not a lot of time, a little time on that. We probably need to set a date to decide when we need to move articles forward for arbitration. And you know, this is the impasse procedures. You know, I think this is in actually the ground rules. We talk about the date. And then we talk about, you know, we won't go to the press until we declare to each other. We promise to do that. We promise that early on. We plan on keeping that promise. We hope you all do the same. And then we had this long discussion on tentative agreements we could bring forward, and we all agreed to that. I just want to make sure we all understand what we agreed to here. And so without waiving such right, both parties will confer in an attempt to come to an agreement on which issues are in dispute once impasse is declared. So the way I look at that is we're going to meet together and we're going to say, okay, number 2, we don't need to take that one. Number 3, we need to take that one. And what I hope we're agreeing to is that that's all the articles will go forward. We won't agree on a set of 10, and then our side or your side bring another 5 to the arbitrator. I mean, I think that's what this means. I hope that's what this means. I just want to make sure that's what it means to everybody.
I think what it meant was that the parties will get together and try to come to a consensus as to what those issues are, be it 3, 5, 10. win that 20,
Okay.
but that if for some reason that, you know, we said this needs to go to arbitration, and you said that needs to go to arbitration, and we didn't have a consensus, that neither party would waive the right to take those.
I would agree with that, but what I'm saying is, like, let's say I wanna bring 1 and you wanna bring 2, and we agree on 3, okay? But we don't agree on 1 and 2. 1 and 2 can go forward,
Yes,
but I'm saying, when we have that conference, we decide that there, we don't I don't say, I'm not gonna send 1 forward, then I, you know, kinda hide behind the log and send 1 forward later on. I was thinking, and I'm not sure what rule set we use, as long as we agree to the same rule set, right? I was thinking we would reach an agreement on what we can agree on and what goes forward, even if we don't agree on it. And then those are the set of articles
I
going forward. Don't be
definitely think that's
surprised.
the intent of it, but I don't think either party has waived the right to do that, just under the charter amendment language itself. So I think that's the intent.
And okay,
How is it you wanna do it, Paul? I guess, let me ask you that.
I mean, the way I understood it, and that's why I wanted to have this conversation, is that we would meet, and I'll just use 3 articles, as an example. I said, I wanna bring Article 1 to arbitration. Go, well, we don't wanna bring Article 1 to arbitration. Okay, well, I'll bring Article 1. You know what I'm telling you, declaring. You wanna bring Article 2. Well, I don't wanna bring that one, but you declared it, we know you're bringing it. Article 3, yeah, we both can agree we need to take that one, you know? And so those 3 articles go forward, there's no surprises to either side. But what I'm not doing is taking Article 10 and sliding it over to the arbitrator, you know, and say, we want to look at this one too. I think we should have at least that level of trust in our relationship where we can agree to do that, is what I'm hoping.
If we both agree here that, you know, whatever, Article 20, the TA version is fine, then we both shake hands that we're not gonna bring that up to the arbitration.
Yes, yeah, so we agree in that
We're on the
conference
same
committee,
page.
I'm not gonna surprise you, you're not gonna surprise me by shoving it forward anyway.
Yeah.
I just wanna have an honest conference committee sort of thing where we can agree, well, even if we disagree with particular articles, at the end of that meeting, we know which ones are going forward.
Yes,
Does that make sense?
I agree with that.
That's great. I think that helps a lot, thank you. And then, I've never done this before, and I haven't talked to Matt yet, so I'm just really, and you may not be able to answer right with that, but it looks like, this is all from, chapter 174. And it looks like, when arbitration requested, the parties, let me see, it says, will make every reasonable effort, including mediation, to settle dispute with good faith collective bargaining. So, does that mean, and you may not know the answer, does that mean we need to go to mediation, before arbitration? Or do you all know, or do you wanna research that? I can research it on my side, I don't know the answer.
I don't think we have the authority to speak on behalf of the legal department on that.
Well, we'll research.
Okay,
If you can talk to Matt, we'll talk to our.
yeah, we can leave that as an open question, I'm just curious about it, and also, this, again, I think we need to have the same understanding of that, whatever it is, that's all. And then hold off on 2, and, Leonard, if y'all have any questions under that. And later on today, I believe we'll be able to have several articles we can present. We look forward to working with you on we hope we can work with you on the management rights bundle soon. I know it's on your side of the table, I think
We
we're
want to
close.
do that now.
We can do that now.
Oh, okay.
So we do have responses for you for that, I'm calling it bundle 1 and bundle 2, right? So,
Okay.
Bundle 1 being 4, 8, 26, 27, and 30. We also have, I think, a resolution on Article 7, which is that report, that might help. too.
Yeah, that seemed, Tim looked at that and it seemed like a positive
Yeah.
result.
Did he need to sit down with Dr. Paulson?
I'm sorry?
Did he need to sit down with Dr. Paulson prior to us taking that little
I
section?
don't know if you
in
did
it?
prior to, but I think at some point, did you just do it prior, or, it looked pretty straightforward, didn't it? We just like to make sure we understand that.
Okay, then we have that one as well.
Oh, I need to plug in the HDMI.
You should be good to go.
Sure of the day. So Article 7, just because it's not part of the bundle. And you know, and I heard your comment about how you feel like we're being more positional than interest-based, IBB type. And so here's, I mean, this is a small example of what we can discuss. What we decided to do is simply just delete this information, delete this section 8, because I think it's been resolved with the report that you already are getting, and now it's just a matter of like a search function. If this doesn't have to be what we do, obviously I think we've actually done a pretty darn good job in this particular article of trying to come to a resolution,
I would acknowledge that.
Yeah.
I think it started out a little bit rough, but you guys definitely tried to meet our interest on this, and we did yours. We agreed to indemnification. I don't think we really should agree to it, but we did that in the spirit of good faith bargaining.
And we agreed to your language of the indemnification, not just our own. So I feel like there may be some articles, yes, they're not all created equal. But I do think the city's done a pretty good job in trying to meet your interests in every single one. And whether you agree with that or not is.
Yeah. What I would say is, I've said this to my members, I try to do 2 Zoom meetings a week, that there was a phase where I characterized what we're having at the table as very candid, very honest, very productive conversations. It seems like we're kind of heading to a little different era. That's our concern.
Okay, and I understand, thank you for letting us know about that. Here, all what we did is just delete the payroll information report. I think that we have basically resolved this issue. So
where's the writing that resolves it?
There is no writing. I just put a footnote that the current report will suffice. And again, we are open to suggestions here because y'all already get a report, and I think it's just a matter of a search function with Excel, which I myself am not.
Yeah, the directions were on the current reports that were given.
Oh, okay.
And another thing that we are offering is, and I don't think we can put this in the contract, is that Tim call Renell, am I correct?
Yeah.
Call us as opposed to the payroll. They're gonna know more just internally anyway.
So that's a part of the bargain here, right? I mean, he can call Renell, he has to resolve an issue, and we're not gonna have 3 years from now that stop like it did before on us.
Yes.
Or we couldn't
We
call,
just
it
created.
wasn't Renell, but we could call, we could call payroll, then we couldn't because I think it's some legal determinations. That's something we're agreeing on.
Yeah, I think it was being couched as like a public information request, which legal and internally they have very specific protocols for. But since we're already giving y'all a report that has a lot of this information, we're gonna try to fix what y'all need with a search function and then just the ability to call Renell.
Okay.
And it'll initially be Dr. Paulson, and then once everything is running smoothly, it will be another person in the internal HRD from the fire department as opposed to corporate.
Right. That works for you, Tim? Okay, we appreciate that. Thank you.
That's 7, Article 4.
So we're ready to TA that, right?
Yeah, new stuff. If y'all are okay with us deleting that new section 8 that was originally proposed, yes. Article 4, we are okay with your changes that I think you added in, make minor modifications to existing. We are okay with this, so we have no changes on our end on Article 4. I realize it's a bundle, so just to go over that.
It seems like some of the other articles in that bundle have crossed without any changes. I don't know. I thought that indicates something positive. I guess we'll find out here.
Article 4, okay. I want to say in this bundle, we are very close, Bob, so. Article 8. No changes in the first paragraph. We left your language here as this case word right here. The only thing that we added was factual issue of a case, because really that is not what we, as if I'm the advocate for the chief, or if I'm the attorney for the Civil Service Commission, we really aren't supposed to opine on any of the factual issues. The commission is the fact finder, but we may need to opine on a legal issue of the parameters of what the commission can do in terms of level of discipline or what they can do under 143 or the contract. So I think this needs everybody's interest in that regard, but open to discussion and, you know,
Yeah, let me
Yeah.
talk to Matt about that. That doesn't seem much different than what we were proposing, but sometimes I can be easily fooled on these things. Let me talk to our attorney, but I appreciate it. It sounds like we're trying to
okay.
reach a good place here.
Article 26. And I believe there was some, well, we've had lots of discussion on this, right? We've had some discussion when I was here, we had some discussion when Will was here, and I think there was a comment that I may have said something that conflicted with Will, and so I wanted to just kind of clear that up or have further discussion on this. Because I believe when you and I were speaking about this, I was generally talking about impact bargaining, but once we've signed the contract, right, then we're done bargaining, unless something comes up that, typically if something comes up that the city wants to do, we're just gonna wait for the next negotiation cycle to bargain. But if we're doing something that does have an impact, then we would say, yeah, we should probably come back to y'all and make some sort of change. But, so I think that's where there might have been some confusion on my end, and Sarah, let me know if I'm saying anything incorrectly, but.
See, I thought impact bargaining was broader than what I was talking about. I thought impact bargaining was just about any impact. And again, my understanding of it is very weak, and I've heard that before. What we're talking about is negotiating on mandatory subject of bargaining that are not necessarily past practices, that are not explicitly permission given in management rights. And so the Wildland Division, the Wildland Battalion is a good example of that. So they created a wildfire battalion. And people in that battalion were made to do additional training above the regular firefighter training. They were not provided a stipend. It was not negotiated, and they were given a 2-year commitment to have to stay in that position. To me, that would have fallen in that category. It was not a past practice. It's a mandatory subject of bargaining. It's a major change of working condition, and it's not explicitly granted to management and management rights. And so that's one of the problems we're trying to solve with this. And that's what I thought our language did solve. And I thought we were getting closer to that, but maybe we need further discussion. But that's a good example of what we're trying to do.
And maybe it needs some tweaking on the language, but the way it's currently worded makes it seem like even after we've signed a deal, then we have this continuing duty to bargain. And that's just not something that we agree with. We sign a deal, and whether it's a 2-year, 3-year, 4-year, any issues that come up that we want to change, we're just going to bring them up next negotiation.
So how would you deal with an issue like that then? So, all the circumstances I just talked about kind of weaves to those different articles of the contract. And management pops up and changes working conditions in a significant way. And what you're saying is, what I think I hear you saying is, well, that's okay, because you're in the middle of a contract.
Well, I don't know if that's what I'm saying. I'm not saying that
You
that's
might not
okay.
be, that's why I'm asking, that's what I'm hearing.
Well, in terms of the wildfire example that you're giving, I need to get with the city team to get a little more information. I know you're telling me one thing, but I don't know enough about that.
Well, I mean, if you just assume what I'm saying is correct, which, it normally is.
Well, then I'm gonna give you the.
It's a 2-year commitment, there's no stipend, it's significantly different work. Now, we're not talking about, just to be clear, we're not talking like, hey, lieutenant says, I want you to put the broom in that clause or that clause. That's a change of working condition, we need to stop. That's not what we're talking about. You're talking about significant changes in working condition. And so why would there be, so you could even have it, I mean, I'm not saying that was done devious, I don't think, but it could be that, we're not gonna tell labor we're doing X until the contract is done. We're gonna get a 4-year contract. Then we're gonna jump up behind the log and say, we're doing X. There's nothing you can do about it because we already signed a contract. Even though it's a significant change in working conditions.
And I don't know if that's what happened in this case, but in terms of like a hypothetical situation or what might happen in the future, I think the typical lawyer response would be, it depends. So, but in the particular instance that you're telling me, I would just need to go back with the team. But I would say.
That's what we're trying to fix. Whether it's hypothetical or the actual practical example, that's what we're trying to fix. And maybe there's a better way than this wording to fix it. We're not trying to, and I don't think this will happen very often, I'm not trying to say that, you know, we don't wanna be the type of association where every little single change we halt. We gotta do a contract, but significant things, I think we can make the case to, I don't know, the arbitrator or district judge, whatever we decide the resolution is. I think they need to be talked about. That's why we have collective bargaining, talk about wages, benefits, and working conditions.
And I think here, we've asked several times for this to be reworded because we're not comfortable that this doesn't go further. You called this the other day, you're just trying to retain the rights that you have. And the way this is worded, we don't think you have this right currently. And we asked, is it impact bargaining? Let me check with Matt. You came back, you said, no, he's not talking about impact bargaining. Had he said yes, that would have made perfect sense to us. The way this is worded, however, doesn't make sense to us. So maybe if you tweaked it, maybe if you clarified it, but this is too broad as it's worded. So I think, we can't accept it as is. We would be willing to accept it in a different.
But is there a language, like now that we've explained what we're trying, and you know what language might be acceptable to you, you propose something that can be acceptable, right? Is there something that you can say, hey,
we would
here's how I think
propose
we
status quo.
can do?
Okay, because last time you put across the table, you didn't have it struck, and I thought that was encouraging.
I don't think we had it struck because there was a footnote, to get with, that we were waiting on a response from Matt.
I didn't notice that's on me, but, okay, well, you know what we're trying to accomplish.
This is where like the frustration comes in, right? Because you're saying, hey, this language isn't acceptable to us. Why don't you rework it to some unknown language that might be acceptable?
I think what might help more is to get with Matt again, because for some reason, I really believe he does mean impact bargaining. And I understand that you're saying you don't understand what that is, but if Matt doesn't understand what that is, maybe he should.
No, I'm sure Matt understands it.
I really think that's what
got it to me, and I'm probably wrong, I'm sure it's got it correctly. He said it's like, it's broader, it's a little broader than just mandatory social bargaining, impact bargaining generally. And I'm just trying, I'm reading this, the parties will acknowledge the duty to bargain collectively in good faith, continues during the term agreement with respect and mandatory substitute bargaining not covered in this agreement. So I guess I could add something like, it's not explicitly excluded in management rights, it's not a past practice. And I could put some more things that filter it down a little bit further maybe. That's exactly what we're trying to achieve. And I think it's something we should achieve. I mean, again, why would we negotiate at arm's length so aggressively with each other to try to reach a bargain, and then we sign it, and then literally the next day, management could change significant working conditions with no repercussion? Why would we agree to that?
That would be impact bargaining though, so that's why I'm not quite sure that we're not on the same page.
Maybe we are.
I think we are on the same page, because the city's interest is to get an agreement, whether it's 2 years, 3 years, 4 years, and then not touch it again, or deal, for another 4, and leave what we've agreed to and what we've negotiated in terms of all these articles that we've discussed till the next time around.
They haven't done that. I guess that's why we're pointing to the wildfire division. We think that's a significant change in working condition. We surveyed everybody in the wildfire division, all believe it's a significant change. It's had a dramatically negative effect on morale. We have the town chief busting down a rank to get out of there. We got people leaving like rats off a sinking ship. And it could have been negotiated, and I think it's actually not a bad idea, So again, whether it's impact bargaining, whether you call it, red or green or whatever, what we're trying to do is bargain in good faith, continuing during the term agreement with respect and mandatory substitute bargaining not covered in this agreement. That's what we're trying to achieve. So I don't know why we wouldn't.
Yeah, I think that's just a problematic example, because when you brought that to management's attention as a significant change in working conditions, they disagreed, and so you filed a grievance that we know is kind of hanging on this as well. So it's not that simple. This isn't going to clarify that answer. They still probably would disagree.
No, our grievance is much more narrow than that. We hope we could figure the broader issue out in bargaining. So, what we're trying to do in bargaining right now, before the agreement is signed, is get an agreement that we can live with going forward, right? I think we all are. And we have a problem. And And we saw an example of it. We've seen other examples, but we have a more recent one with Wildfire Division. So we're trying to figure out how to solve that problem. To me, that solves it. If we put a few more filters on there, it might make you feel a bit better, so we'll try to do that. I think I have some ideas for that, maybe Matt will too. But I mean, in the end, this is pretty important to us. I mean, why would we sign an agreement and management can literally change the agreement afterwards with no repercussion? It doesn't seem like something we can agree to.
We don't believe that's how it currently reads.
Well, they can't change the written agreement, but they can change working conditions and aren't in the written agreement without repercussion.
All right.
Just say it one more time. That's
I understand your guys' frustration. Okay? I came in at evidently a juicy part of the conversation, okay? But let me just say this, I understand where you're coming from on this issue, right? I'm putting myself in your shoes. You're saying, if under the current language, y'all think that you have the ability to create the Wildfire Division and do X, Y, and Z, and not allow them to do A, B, and C and transfer out, and you have to stay minimum 2 years, you thought that was a mandatory subject to bargaining. And so you're trying to rectify that here, or in management rights, wherever the heck it is, you're trying to rectify that situation, right? And let me go back, we'll look at the Wildfire Division issue, but I believe what it may be is that the city felt under the language as written that it was either not significant change, it was not, whatever it was, that they had the management right to do that. Whatever happens with that grievance, I understand your interest is in trying to make sure something like that in the future, right, is rectified to your satisfaction. Let us go back and look to see what we can do to try to meet those interests if we can.
No.
I mean, obviously, as you know, Bob, one of the main issues that we have on the management side is, operational control. And there's a level that we wanna, concede on to try to get a deal, but at the end, every chief wants as much operational control as possible, and not to say, well, I can't move somebody to this division because, the union hasn't agreed to it yet, and we gotta sit down for 60 days, do X, Y, Z. So that's normally kind of the rub between union and management when it comes to operational control. But let us go back. I completely understand what you guys are saying. I understand what you're saying of if you feel that there's better language, why don't you guys come up with it? And I think we will. We'll try to see if maybe our answer is just the same, but we'll have a deeper discussion into this issue.
But, you said it before, most of our issues in the past have been operational. And if you look at the issues we've been involved with, we weren't trying to take authority from management. We were trying to help make a better product for our citizens. At least we feel that way. Right. And we're not trying to stop the wildfire battalion. In fact, you guys may or may not know this, but the association actually set up the Wildfire Division. We got a $2 million funding in 2011 from the city council. And the fire chief said, no, we don't want this. And so we actually got a division the fire chief at the time didn't want, which has flourished and reduced the risk in the city significantly. So we're not against this whole effort. We're just against the way it went about. And I think you do understand where we're coming from, so I'm just kind of adding to that. But the grievance does not cover the broadness of what we're trying to accomplish here at the table.
I get you.
We didn't try to challenge this between that contract. We figured we need to set the table. We don't need to hide behind the log. We're going to be honest what we're trying to achieve. That's what we're trying to achieve.
I get you. And I think just before we get to the financial piece of it, what I came in on was frustration on your guys' end that we didn't go through a deeper dive explanation. We felt like we just kind of dismissed some of your requests. I can tell you that that's not the case. We're looking at, especially with this being the first year of a 3.5% cap, we have looked at all three of the proposals from all three of the unions, in addition to what civilians want, in addition to what everybody else is asking for in the city. And we're taking all of that into consideration. I think that we wanted to get our information out there, but today is a day that we need to do a deeper dive into explanations. I think that also on our end, I think there are some things that we think y'all understand, but maybe your membership doesn't understand it as well as we kind of assume that they do. For example, we haven't really walked through the impact of the 3.5% cap. We've just talked about, hey, this is our first year of a 3.5% cap. I can tell you there's frustration on the city side as well, that the association knows there's a 3.5% cap, yet they're asking for 13-point-something% minimum the first year. Like, how do we rectify those two things? So I know that there's frustration, and there's bound to be as we've done this long enough when it comes to financials, that there's bound to be disagreements. I want to go through a deeper explanation to y'all as to why we got to where we got to. You're not going to agree with it, but I want you to know where we're coming from, and it wasn't just a dismissal of your guys' proposals. But suffice to say, that's what I came in on. I don't know if I understood it all correctly, but I tried to put two and two together, and that's what I came up with. That must have been the conversation. So.
No, it's fine, and we need to talk about 3.5% cap and what's involved and what's not. For instance, you all made a statement on your side of the table that ESDs are not subject to the revenue cap of 3.5%. That's not true. Every single ESD in the state of Texas is subject to the revenue cap. Every single one. And the revenue cap is a percentage of total income that first of all, revenue, property tax revenue is only a percentage of total revenue. And then it's only included for residential and commercial. It's not for new construction, it's not for debt service, which is significant, which we can go over the cap for those two things, okay? So to call it 3.5.
Are they not at a 10% cap as opposed to the 3.5% cap?
They have both caps.
Okay, I don't think that's our legal understanding of it, but we can relook at that.
I can send you a video and a white paper from one of the foremost attorneys in the state of Texas for ESDs to go over that in detail.
That would be great, because our understanding was they were.
And so, for instance, ESD 11, who I called the other day, they're an effective rate now. I think what we call it is the no tax rate of, I think 9.7%. They can't go their 10 cent, and what's stopping them is the 3.5% cap. And so there seems to be a lot of misunderstanding on this issue, and it'd be good to go through it and understand it better. We've done enough research to know that the city can afford to pay firefighters a cost of living raise. And that's all we're asking. You'd think we're asking for the moon, like some crazy stuff. We're asking to maintain our purchasing power in the hottest economic environment in the nation. That doesn't seem that unreasonable. I know we can get there if management actually appreciates the work that firefighters do. And they're looking to management for that appreciation. I don't know if you guys understand firefighters that much. Well, I don't think I do. I've been there 36 years. But, they work hard. They'll do anything you ask them to do. And they expect management to support them. This does not look like that to them. I'm not talking from me. I'm talking what I'm hearing from my members. And in high stakes jobs like military or fire or police and EMS can be included that too. Appreciation from your commanding officers is incredibly important for morale. And morale is probably one of the most important currencies we have in our department. And morale is going down. We're looking for y'all, and you guys aren't even the managers of the fire department. We're looking at city to help support our firefighters on a cost of living raise. That's not a crazy ask. It's just not.
Well, I guess, let me just say, one of the other issues with the ESDs is compared to cities, they have less duties that they have to provide their citizens compared to what cities do, right? But moving past the ESDs, I know, unions love to say, well, if you appreciated us, this is what you would do. And it's not for a lack of appreciation. The arguments you're making on a cost of living adjustment and purchasing power is the same thing that, 15,000 of our employees are going to make. It affects them the same way. And in fact, as we talked about before, the cost of milk going up 8% affects our lowest paid employees on the civilian side far more than it affects, the higher paid employees. And that's just the reality. So there's budgetary balances we're trying to do, and I know that we're not going to be able to give everybody everything that they want, and we're trying to do the best we can and trying to balance the budget. So that's just where we're coming from. I know that that's not something that any employee group likes to hear, be it you, police, fire, EMS, or frankly, our civilians. No one wants to hear that, but that is the answer that we have, and we're trying to balance it as best we can, looking out for everybody's interests as much as we can, but there's a limit to what we.
You guys have a broader concern. I'm looking out for the interests of firefighters.
I know you
are.
are.
Trying to make a justified case that number one, you can afford it, and number two, that it's necessary and justified. And we're not asking for the moon here, so I think we can get there if we really want to. Anyway, getting back to this. I think this has probably been a fruitful discussion. I'll get back with Matt. And hopefully we can turn this around real quick. I think we all understand exactly what we're trying to accomplish and what we're not trying to accomplish, so that's good.
Okay, Article 27 is part of this bundle as well. And so I know I haven't struck this or anything, but I mean, we are also, I mean, I think one of the things that even Lowell said last time was that this is really beneficial to both parties, and that's kind of how we've been couching it and how we've been proposing it this whole time. And so we don't really feel that this is like seeing y'all's agreement to this language as a concession or a really big concession, because it really does give a roadmap into past practices and what the standard is. That being said, I think we are willing to kind of go back to status quo. We can remove this language if that's going to kind of get this bundle done.
I mean, we look at this as a concession, but it's a concession we're willing to make, you know, if we can get this bundle done. So I would say it's up to y'all. If we can get this bundle done, and you go, this has some value to us, whether the association, we think it has value to the association, whether they want to admit it or not, you can leave it in. If you guys, if we get the bundle done, and in the end you go, you know what, this doesn't add value to anybody, then you're free to take it out. But we do look at it as a concession, and because if we had our preference, we'd rather have it out, but we're willing to put it in if that edges us towards getting a deal on the bundle. That's just the way we're looking at it.
And I think that we are willing to take it out if it edges us toward a deal on the bundle. So, I mean.
Yeah, okay, well, I'll leave it up to y'all. How do you want to do it?
Fair enough.
But it's a big concession for us, so make sure you're ready.
Article 30. So there has been a lot of back and forth, so I'm gonna do the view to
Yeah, that's probably a good idea.
the simple one.
Click on that little arrow on the tracking underneath it.
There, oh, yeah. The Walmart.
Go to Walmart, and then go simple.
Oh, no.
There we go. If the parties are engaged in negotiations and or dispute resolution procedure, so we left that in there, that was part of y'all's proposal, for a successor agreement at the time this agreement expires, the associations and the city's negotiating team shall have the authority to extend this agreement in 6-month increments by mutual written agreement after such termination date specified in section 1A above, not to exceed a total of 1 year. So really, I believe y'all had a year in there. We're not opposed to going to a year, especially if we are in dispute resolution procedure. Our main objective is really just to make it mutually, it's gotta be by mutual agreement.
And that's our main objective, is to make it where it's not mutually agreed. And I thought we were meeting your interest because we did it for a period of time while it was we're actively trying to negotiate a contract, right? But we feel like case law is very clear on this, that we have that right, we're giving that right away here if we agree to a mutual agreement. We think we have the right to do it. We think you cannot change conditions of our contract while we are in active negotiations, even after an impasse.
Well, I would say that while we are in active negotiations, we don't disagree with you. But if we have reached an impasse, then we are no longer in active negotiations, and therefore the contract is expired. And to continue any of the articles beyond that would need to be by mutual agreement, unless it's specified in the contract, which I think is your goal, right? So you're trying to specify that in the contract.
So,
And one of the things you can, if you show the other markup, and you don't need to, I can just tell you, you take my word for it. The way it currently reads is in good faith negotiations. So the way it currently reads, an impasse would automatically make that impossible. You're not in good faith negotiations if impasse has been declared.
And so we took that out. We took that out
So that this could happen.
so that this could happen and dispute resolution to include going to impasse, going to arbitration, because if we are at impasse, we're no longer in good faith negotiations. We're at impasse, and you can get mad on that, right? So, we took that out to include that we can continue the term of the agreement for up to a year. But it still just has to be by mutual agreement.
Yeah, that's the part we have an issue with. And we think we're giving away a argument we can make in court. We believe that, like, let's just talk hypothetical. So if we're at impasse and let's say y'all decide, let's just say we decide that we'd like to go to final arbitration. And y'all decide, I'm not saying you would do this, let's say y'all decide we're gonna slowball this thing. We're gonna be late on getting the arbitrators, we're gonna try to pick the dates that are the furthest down the road as possible. You know, so you could probably, rather than getting it done in 45 days, like the statute said, you could slowball it to 4 months, 5 months. We want the bargain during that time. We don't want it to be mutually agreed to. We think that the bargain should stay in place until we finish the dispute resolution procedure.
Do you want to go into the specifics on your interpretation of Matt's case law?
Well,
Just so that they know where we're actually coming from.
yeah, and I guess, and I think Wolf said this last time around too. I think nobody wants to have to just revert back to 143. I think it would just be a complete chaos, right? So if we are in either good faith negotiations because we've extended the 15-day increments, or we decide to go to mediation prior to binding arbitration, or if we're in arbitration, I think the chances are is that most likely than not, that we're just going to agree to extend this contract for as long as we need to extend it. And
I guess what I don't really understand, this might be the crux of the problem from our side, or at least my side, is that I don't understand why you wouldn't agree to making it automatic and not mutual if you're in a dispute resolution procedure. What is the thought process where we have to make it mutual?
well, okay, so if we, and I think this goes back to kind of the interpretation of the case law that Matt and I have been looking at, right? So I don't disagree, and I don't think we disagree, that if we are in the middle of good faith negotiations, then there can be no unilateral changes by the employer. I mean, this is just NLRB guidance, right? I think there's certainly no case law in Texas, and I think when you throw in the fact that it's fire and police and 174, and it kind of changes the aspect of just some other industry, right? So there's a few little nuances that may play in here that would be getting into the weeds. But if we're looking at NLRB guidance, we don't disagree that if we are in the middle of good faith negotiations, then we're not going to make any changes to the contract. That's the NLRB guidance. But if to move forward to arbitration, one side has to declare impasse. And once we are at impasse, then we are no longer negotiating. And so if you look at NLRB guidance, it would seem to indicate that yeah, you can make those changes. You can. And so I'm not saying that that's something the city would do, but we would be waiving a legal right that we have, or that we feel that we have, in that regard. And I'm not saying that we would do that, but it gives us the option to continue it, and we can go beyond a year. I think we said that too. We can go beyond a year. We can go, whatever we need to do in that regard. But
so
if your fear is slowballing it, maybe there's a way that we can say, well, we'll mutually agree to this until the end of the dispute resolution procedure. I don't know. I mean, I'm just thinking out loud here at this point.
We'll take a look at it again. I'm telling you, this is going to be hard for us to reach an agreement on, because I do not, even with your explanation just now, I don't see what you fear. If impasse is declared, it doesn't need to be a side declared. It's like 60 days pass, it's declared. If without
right.
It doesn't have to be somebody declares it, right? So we're in impasse, and we send you a request for binding arbitration. We're in a dispute resolution procedure now. I don't understand the fear the city would have in saying that during that period, while we're in this legitimate dispute resolution procedure, that the agreement wouldn't continue. That's what I'm having trouble with. I don't see why you would say no to that. It seems so basic to me that if if you're going to arbitration in the future to settle this impasse, why would we change the bargain during that time? I just don't get it.
Yeah, you think this language is a concession on your part. We think your language is a concession on our part. I would say this, you talked about, just kind of going past the, the PR language and just having open and honest conversations. Open and honestly, y'all start negotiations sooner, because y'all normally go last. You start sooner, this is not an issue. Start in October, get to impasse by December. We're gonna have arbitrator decision by October. But traditionally, and I don't want you to take offense to this, for whatever reason, traditionally fire wants to go after police, after EMS, and that does impact kind of when the arbitrator's decision will come up. But if you just say, you know what, we're ready. Y'all put in a lot of work finding videos, getting the clips. Y'all put in a lot of work to get ready for arbitration. And you normally do that because you guys are really good and you as the president get your team ready. Y'all prep for bargaining far earlier than we do, because we have 3 to prep for, obviously. So if you just start earlier, none of this is an issue. So I know you're asking, what is the harm? I would throw it back to you. What is the harm in just starting earlier? We won't end up going past October.
Well, it seems like conflating issues. I don't mean to be offensive, and I hope I'm not, but it just seems that to me, what does the start of bargaining to do with what you do after impasse? Those seem to be totally separate things, but we want to talk about why we didn't start earlier. Maybe you shouldn't have sent me a letter at the end of February saying you're not going to abide by the will of the voters. We would have started a month earlier. So let's just not go there, because it doesn't matter when we start. To me, that doesn't even make a cogent argument. What matters
So let me be a little more clear. One of the cases that Matt cited in his initial footnote, Becky is telling you that we agree with that. That was the Katz case, right? And so that's if you're still in good faith negotiations. The second case that he cited, we believe, is the reason you have to have the language changed.
That might be helpful.
Because currently, it isn't the case, in our belief.
And why do you feel that? Could you expound on that?
Because the case basically says that absent the language in the contract, that's not true. Right. And you don't have the current contract language that reads that way. You're trying to change it to that way. So it would us be specifically giving up our current rights. We're not afraid or fear or this or that, but why would we give up any current rights that we have?
Why?
It's not a
Because
bargain.
that's what you do in an agreement.
Well, but you're not bargaining.
Certain rights.
But you're not bargaining anything for it. You're just asking us to give it up. So that our position is that both of those cases didn't support the stance. One supported it legally, and the other is why you need it. So it was kind of 2 different aspects of cases that were presented. So legally, currently, we do not believe after impasse that this would be true. So
Well,
we are not looking to change.
I appreciate your opinion on that case law, and we'll take a look at that. That could be helpful.
I think that's our primary problem with all of this.
I don't think that necessarily means we can't agree to an extended period that's not mutual, but what you're saying is you believe there's a right that you, not that you would necessarily accept, but you may need depending on what the circumstances.
We quite frankly don't think we would, but we can't say that for sure, but we would be waiving it if we agreed to this.
But you can certainly understand why we would have some angst with not knowing what's gonna happen in that period, only depending on, a mutual agreement, right? That could be, you can understand why we would resolve that, I'm sure.
Right, and for us to change from the status quo, we would need some sort of.
It would be a huge concession. We see this as a huge concession if we were to put in like an automatic triggering for that. And that's basically what that case says, is that subject to specific language in the contract that's going to extend this, then the employer retains their duty to do what they need to after they've reached impasse, or when they no longer are in negotiations. And so by default, we're in impasse, we're no longer in negotiation. And like Sarah said, I don't think we're ever going to, exercise that right, but it would be a huge concession legally for the city.
I'm sure you guys have your reasons for calling it a huge concession. It doesn't seem that huge to me, but our whole contract is premised on changing law and coming to an agreement that we can both agree with, right? I mean, that's not just this, it's the entire agreement almost is prefaced on negotiating around baseline laws. So to us, it just seems like another baseline law we're kind of negotiating and trying to reach a meeting of the minds on. But you've given us lots of good information. I appreciate the exchange. I'll get with Matt and we'll get back to you. So I'm assuming once you present these, you'll send these over to us today.
Yes, I'm gonna
Okay.
send them over right now. So that's what I have for right now. I think we are ready and willing to go over what we emailed you.
Sure, we do 30.
Oh, that'd be great.
That was 30.
Okay.
But I would say, do you want to take a break for a few minutes, so I can pull them up? I only had this bundle pulled up, so,
I'm sorry, I didn't hear.
I only had this bundle pulled up. Do you want to kind of take a 20-minute conference or something like that?
You know, it's almost lunchtime. I don't know if you guys have stuff going on at noon. I think sometimes we do. I'm willing to come back, or I'm willing to wait a little bit longer. We've got work to do either way, so don't want to bother us.
We have at least 5 to go through, so that would take probably at least an hour.
Can we do like 12:30?
Yeah.
Is that enough time
Yeah.
for lunch, or did you need to go outside?
12:30, I think it'll be fine. Tim, you know what time food's coming in? Yeah, okay. And we got those articles you sent yesterday we need to go over, so we've got plenty of work to do. It's not gonna stop us if we come back later. So, come back at 12:30? Okay. Good to see it, and it wasn't delayed or anything, that's great. I'm sure that's an issue.
Tim, let's look for a time in the next week or so, let's look for
Okay.
a time to, I don't think it'll take a lot to just
Yeah.
go through the steps.
But it is a different file than I get right now, right?
No, I adjusted it, it's the same file you get now, I did some adjustments in Excel, so
Okay.
I'll teach you how to do those adjustments.
Yeah, I've used lookup before, and I mean, I'll be honest, really what it's gonna come down to is I already have separate worksheets where I track each one individually, so I probably do more work than I have to.
Uh-huh.
And it's just a matter of calling about really specific people, and sometimes there's no one.
Yeah,
So
This-
like
and
this
this
last
time-
payroll, there was someone, and it's like, hey, Andrew Thomas.
that's what I figured, you probably know the situation
Yeah.
for most people.
Yeah.
It's just, if you email me, I'll get whoever,
Yeah.
whether it's HR or payroll, whoever. But I think I might save you some time. It took me a few minutes to figure out the lookup function,
Okay.
and comparing 2 lists at a time, and I felt like I learned something in the
Yeah.
process, so it'd be good for me to share.
Well, I appreciate it.
Sure.
You sent me a letter at the end of February saying you're not going to abide by the leave now. So I'm not gonna go any further.
Yeah. I changed it to 1.
To what?
To 1 o'clock.
What about?
Start, restart.
Oh, okay.
So, I talked to both of them. And the food is delayed, so. We aren't doing well today, are we?
No.
guy you call, where does he work from?
ATXN. He's the one who would set it up. Help me set it up for the stream.
It's my text.
Oh.
It's recording. I need to turn this off, I think.